trial team at the junior high, high school, and college level during those years. And I brought my program out to my new home state. What we're trying to do here is develop a law program that begins here at Olive Children Foundation and extends to the Fremont public school system. We're already in the works trying to get a mock trial team club started at the high school. That means that they need to get an advisor from their staff to be an advisor to a team. And if you have a team and you have an advisor, then you're eligible to join the competitive Alameda County mock trial tournament, which includes 20 or 5 or 30 schools in all of Alameda County. Those schools are assigned an attorney to work with the advisor and the students. They're given all the same court case around November of each year, and they prepare the case like you've seen here, and then starting in February, they go to the actual Alameda County Courthouse where a sitting judge hears their case when they play each other in a round-robin tournament. The winner of the county tournament takes on the winner of another county tournament until finally they appear in Sacramento somewhere around April or May for the state championship. If that is decided, that lucky team that has gone through an entire season undefeated, they go on to a national tournament held in Washington, D.C. So this is a kind of a huge program that starts at the lower level and works its way through. Fremont Schools, to my understanding, does not participate at this point in time in the mock trial program. I highly recommend they consider it. The skills that you saw here, I think, let's not give a hand to these 6 people for what they all you saw was based upon 10 weeks of work at about 2 hours a week, a total of 20 hours total with me. And they developed the documents, the concepts. I helped them where they requested it. This is their first experience doing a trial, and the trial they did is a negligence matter, but there are many others. I've written over 200 court cases, and they vary in degree of difficulty as time goes on. Had we had a bigger number of students enrolled, you would have seen a different trial. Why? Because we would have had expert witnesses testify. McDonald's would hire an expert witness to testify to how hot the hot chocolate is made and how it is served uniformly, and there'd be an expert on the other side to contest that and say that on this particular summer day the air conditioning was piped up and they made it extra special hot. And then, like always, you'll have to decide which expert to believe. Many times what juries do is they disregard both experts, which costs a lot of money, but they sometimes say, I can't decide, we'll throw the expert testimony out. I think you saw that happen in the O.J. Simpson case. They couldn't decide what to do, so they said, we'll disregard the testimony that 1 in 3 billion people could have done this other than him. We'll just forget about that. But the case would have been more witnesses, but because we had a small group, we stuck with just the 1 witness for each side. So we're hoping the program develops, and these fine 6 people have worked really hard these last 10 weeks. They're doing something they really haven't done before, and I think you can easily see the critical thinking skills that are involved. Some of them even came up and did redirects without any notes at all, just by listening to what they heard going on during cross-exam, which is a very high-level skill, to process all those questions and figure out which ones to ask your witness a second time to have them kind of patch themselves up if cross-exam was somewhat distressful. And so, is that what you'd like me to do?
Oh.
Now, when everyone sits down, I'm going to be asking the jury foreperson a series of questions, okay?
Okay.
First of all, without revealing the verdict, has the jury reached a decision in this matter?
Yes.
Okay. Did everyone, in your opinion, have an opportunity, if they chose to express their opinion? Did they have an opportunity to change their mind?
Yeah.
As time went on, if they were influenced by the arguments by other individuals?
Yeah, we had quite a few opportunities.
I'd like to have the plaintiff and the defendant please stand. Just the witness, please. You are bringing the charge of negligence against the McDonald's Corporation, and you are the manager of McDonald's, Ms. Drew. And what is the verdict of this jury?
Okay.
And by what vote?
Okay.
Without revealing names. Was it 7-1?
So, a 6-1 decision. We, the jury, find the plaintiff was partly responsible for causing his own injuries, but is still entitled to some damages. We therefore award 50% of the $8,345 to Tony Clark, We also award 10% of the $50,000 in punitive damages to Tony Clark.
Thank you very much. You may sit down. So, you can look at that any way you want to look at it. The plaintiff has received half of their medical bill payments. The defense has avoided a majority of the punitive damages based on your verdict. So, here's the question then. What was the important testimony? And anyone can answer that was in the jury. What do you consider the most important, compelling testimony from both sides? Because they'd like to know, I think, what actually you hung your hat on. Because they both won this case. You got half of your money and $5,000 extra in damages, and you saved, $40,000 of punitive damages and $3,280 of compensatory damages. So both sides can walk away feeling good about the results. What was it?
Well, we partly felt that just as a logical thing that when people order something hot, like as both sides actually testified, on the menu it was hot chocolate, so as a few of the jury members brought up, if they're ordering something hot, when they grow up they know it's hot and they know they shouldn't chug it down. But then the other part we brought up, which is why we didn't award the full punitive damages to the plaintiff, is that since McDonald's didn't warn the customer at all, didn't have any warning labels on the cup, and it was a styrofoam cup, that might be, I think both parties were at fault here. So both testimonies really fueled our decision.
Now this was a real case. The only difference is I had to change things a little bit. It was an elderly lady that was burned rather significantly at McDonald's. And the first award of the jury was $3 million. And when it was on appeal, which is everyone I'm sure understands, the defense was unhappy with that verdict. The McDonald's Corporation was unhappy with that. They filed an appeal, and on the appeal, the award was reduced to $1 million. If I had known that from all the times I bought candy bars that had bugs in it when I was a kid, I would have done something about it. So once again, this was not a local McDonald's. But I'm sure you realize as adults now that things have changed in the fast food industry. Sometimes the cups have the word caution hot on it. That's because of this case. So lawsuits can be frivolous, but they can also be very important in making changes that businesses don't necessarily want to make because of the cost factor. So McDonald's had to pay not only a larger amount of money to the elderly woman, but they had to reconfigure their cups. But on the other side of the coin, how did you feel about the argument that the defense gave that this is opening a Pandora's box and a can of worms? Does McDonald's have to warn everyone about cold beverages now too?
Well, yeah.
Should there be warnings all over the restaurant? How about how quickly you eat? I'm warning you, you must chew your food and eat slower? I mean, where does it stop?
Yeah, honestly, we didn't discuss that whole slippery slope part. Maybe we should have.
No, I'm just saying that this is food for thought about what actually a business is legitimately responsible for doing. So, I want to thank the high school people. I hope you can stay for the second case. The second case is